appeal in the matter of Kairos Shipping and Songa Port of Lincoln in Penn.
Yes.
Good morning, my lady. I appear on behalf of the appellants, Kairos Shipping, who are the owners of the vessel, Songa. My submissions are referred them to the appellants and the owners interchangeably. My learned friend, Mr. Mills Casey, appears on behalf of the respondents, who are the charterers, bareboat charterers of the vessel. Now let's refer to them as the charterers or the respondents interchangeably.
Certainly.
My lady, there's embarrassingly a bit of unclarity on our side, if that's a word, as to the exact timing for the listing. And there's a difference on, we think it might be a day listing, and then for others it might be a half a day listing. There's a suggestion that it might be a 3-hour listing.
Oh my goodness. Well, perhaps I can help without entering into the debate. The position is we've all had an opportunity of reading extensively into the papers, which obviously includes the judgments, both the arbitration and the judge's judgment and your skeleton arguments. And we think the point is very important, but quite narrow. So I have to say, for my part, I thought today was probably a very generous listing, if that was the listing. I don't know if that helps.
I'm grateful, my lady. Well, I will cut my cloth accordingly, and hopefully you won't be a day. As your lordships would appreciate, this is an appeal from His Honour Judge Pelling KC. In respect of Section 69 of the Arbitration Act appeal from an award of the FAA tribunal comprising Claire Ambrose, Stephen Berry Casey, and Robert Thomas Casey. And as your lordships would appreciate, the central question is one of the interpretation of Clause 29
Yes.
of the BIMCO of the Fair from 2001 times, which is the standard form of the charter published by BIMCO. Now, my lady, there is one small point of housekeeping that it's probably appropriate for me to deal with before I begin my submissions in earnest. Now, as your lordship might have appreciated from the skeleton argument, our appeal documents were prepared without a written judgment being available to us because the judge read out the judgment and the transcript wasn't available at the time the appeal documents were due. And as a result, it was envisaged that there may need to be amendments to the appeal documents. Now, having reviewed the transcript, it was thought that it was not necessary to do so. Now, I understand my learned friend in his skeleton argument says that there are several points where my skeleton argument misstates what the judge says. Now, I don't agree with that, but there is one correction to my skeleton argument that I think is appropriate to make.
Certainly.
My lady, my lords, if I can ask you to please open the core bundle, tab 2, page 26, which is my skeleton argument.
Yes.
Paragraph 40.
Yes.
And in this paragraph, what I'm doing is recounting what the appellants understood the judge to have found. In the final sentence, I say the judge also noted that it is unclear how Clause 29 was intended to work in the event of a constructive total loss, therefore giving rise to termination pursuant to Clause 28C. Now, my lady, my lords, that doesn't appear in the judgment, and if I may,
Shall we just strike that out?
respectfully request that you just strike that out.
Certainly. Thank you for drawing our attention to that.
Otherwise, insofar as my learned friend says that the skeleton argument misstates points, as I say, I don't accept that, and I will deal with them in submissions insofar as it's necessary.
We're very focused on the interpretation of the actual clause with which we're concerned.
Turning then to that issue, my lady, as you'll appreciate from the skeleton argument on a high level, what the appellants say that Clause 29 does in a proper construction is that in the event of an early termination of the charge party, Clause 29 gives the ship owner the right to repossess the vessel from one of three places. Either the vessel's current port of call, its scheduled next port of call, or a place or port that is convenient to owners for the purposes of repossession. So Clause 29 essentially gives owners a right of election. The respondents, on the other hand, I think it's easiest to see what they say. I'm sure your lordships have read it, but it's easiest to see what they say by reference to the skeleton argument, which is tab 3, page 60. You'll see that this is 3A. They say that the effect of 2029 is that the owners are required to repossess the vessel as soon as practical, basically where the vessel is upon termination, or where charterers position as they wind down their use and possession of the vessel and take reasonable steps to keep the vessel safe pending possession, provided that the owners are entitled to have the vessel made available at a port or place that is convenient for possession in the objective sense that allows an authorised representative and crew to be put on board in the usual way. So, in essence, in very simple terms, the difference between the parties is the appellants say charter owners have a right to elect, the respondents say the vessel must be repossessed wherever it is at the time of termination, or wherever charterers essentially choose to put it in winding down the vessel. The tribunal adopted the construction that the appellants put forward before you, and so they did find that the owners have the right to elect. His Honour Judge Pelling disagreed with that and essentially concluded that the owners were obliged to repossess the vessel at the place where she was at the time of termination, unless it was impossible or impractical to do so. And we'll come to look at the judge's judgment in a bit more detail. But those are where the battle lines are. Now, before focusing on the words of clause 29, my lady, my lords, I say it's important to situate the clause in the general context of bareboat charters in the first place, but also situate it in the context of the charter party itself. Now, the first thing I would say is that there are about 4 fundamental principles of bareboat charters that I hope are uncontroversial, but are relevant for your lordships to bear in mind when construing clause 29. The first is that the essence of a bareboat charter is that the owners of the vessel transfer possession and full control of the vessel to the bareboat charterer. So the bareboat charterer has the full possession and control of the vessel at their disposal. In a sense, it's like a dry lease in aircraft aviation terms, or akin to some people say it's akin to a leasehold of real property, but query how far that analogy can really go. But the point is, the charterers have full possession and control. The second proposition is that the consequence of charterers having full possession and control of the vessel is that the obligations that relate to the maintenance of the vessel, insurance of the vessel, repairing the vessel, how it can be traded, where it can be traded, all fall on the charterers. The third proposition, which kind of follows from the second proposition, is that under a bareboat charter, owners have very limited obligations, if any, other than not to disturb the quiet use, enjoyment, possession of the vessel by the charterers. And then the fourth proposition is that bareboat charterers are generally used for 2 purposes. One, borrowing from the language of just leasing in general, is what you might describe as an operating charter, an operating lease. And this is the sort of bareboat charter where the charterer is a ship operating company and wants to supplement its fleet. And so they will charter in a vessel on bareboat terms for a period of time, 5 years, 10 years, with the intention of returning the vessel to the owner at the end of the charter period. The second purpose is what is described as a finance charter or finance lease. And here, the nature of the arrangement is that one party finances the purchase or the building of a ship with the intention that the borrowing party will get to use, essentially treat it as its own. So you insert a bareboat charter into that relationship, whereby the financing party is the owner, lets the borrower have essentially all the indices of ownership, but repay the financing through the hire payments, which are calculated by reference to the
It's like a sale and lease back.
Like a sale and lease back, say that there was no sale at the beginning. And the idea is that whenever you finish paying the hire at the end, there is then a sale and purchase. So it's all
So it's
probably
more like
closer
a
to a
hire
hire
purchase.
purchase.
Yeah, for HP, yeah.
Yeah. And so those are the two purposes you use bareboat charters for generally. Now, as I say, my lord to my lady, I hope what I've said is uncontroversial, but it is probably helpful to see how some of the leading textbooks put some of the points that I've made. Just
To what end? Where does that take us in the
now, all of this is just to support the points I've made in case there is some dispute about it. But the idea is that when you're construing clause 29, you need to understand, because, for example, clause 28 sets out the circumstances in which there will be termination.
Of course.
Well, if there are very limited obligations on charterers to be able to default, then one might think that when they're drafting clause 29, they're not really thinking that it's going to arise in situations where the owners are the people who have been in default and charterers exercise their right to terminate. So it's really just giving you a context of what clause 29 or how clause 29 can arise. I'll try and deal with it quickly, Melanie, just.
But if those propositions aren't controversial, then where does it take us?
To look at the commentary.
Yes.
I'm happy to move along without looking at the commentary. Whether they will be controversial is difficult to know until my learned friend.
They're controversial, Mr. Mill?
I would say I have no objection to the court looking at the commentary, and it may perhaps be useful for my learned friend to develop his point in that regard.
My lady, my lords, the authorities bundle, please, tab 10. If I can ask you to please read. It's probably simplest if you lordship to read 6003 on page 143 and 6004.
Thank you. We leave those to ourselves.
If I can ask your lordships to please read 6012 on page 155 of the download.
So that's your proposition 4, isn't it?
Yes, my lady.
I'm sorry, what was that reference? 6012?
Yes, my lord.
Thank you.
And then at 6013, I won't ask your lordships to read the whole thing, but if I can ask you to please turn to 146, see the final paragraph that starts both structures. Maybe the legal defines here.
What are the two structures?
The two structures don't necessarily matter. They're just two structures, two ways in which a finance lease might be structured. But we don't need to get into the detail of that.
Conditional sale or a hire purchase. Yes, I see.
Thank you.
And then anything you want me to look at 6014. So there's just one more proposition just to make good, my lady and my lords. If I can ask you to please turn to bareboat charters, which is at tab 8. And page 110. If I ask you to please read 1.13, and the point to take away here is the one that owners have very limited obligations. And so, my lady, my lords, that is the general context for bareboat charters. I say one has to place clause 29. Now, turning to back on 2001, you can find that in the core bundle at tab 8. Now, the first point that I would like you all to bear in mind, page 200. Because as I understand it on the schedule argument, there is a dispute as to whether or not back on 2001 envisages the possibility of being used as a finance charter.
So where are you taking us? Page 200.
Page 200.
Okay, thank you.
And this is what is described as a hire purchase agreement. And if your lordships read the first 7 lines, of course they're cancelled out, they don't apply in this case, but this is the standard back on 2001. You'll see that that essentially gives effect to a conditional sale in the way that I described earlier. So when the financing is repaid completely by hire, purchase of the vessel is then given effect to.
So where is that?
So the first 7 lines of part 4.
Page? Sorry.
Page 200, I beg. And the point I make is that when construing the standard terms of BERCON in 2001, one has to do so in a way that makes it work equally and sensibly for both operating charters and finance charters.
So this is an optional part.
Indeed, my lord. And in this case, it was not. The parties did not agree to use it, but it is a standard part of the standard form of BERCON 2001.
So the fact that it's not applied in this charter means that on expiry of the term, what was envisaged was it would be redelivered to the owner.
Indeed, my lord. Yes. Now, if I may ask your lordships to turn to the front of tab 8, so the start of the BERCON 2001, page 188. Now, the way that BERCON 2001 works is that this is part one, which is essentially a series of boxes that the parties can negotiate and fill in based on whatever their negotiation agreement is. And part two contains the real standard terms from page 190. And then you've got parts 3 and 4, which may or may not apply depending on whether or not the parties elect that it should apply. The point of note to take away from part one of this particular charge party, and it's a point that my lawyer is box 16, which is titled Port or Place of Redelivery, box 15. And there it says, one safe port, berth or anchorage worldwide in charterer's option, but excluding North Korea, Cuba, and always within international navigational limits. The point that my learned friend makes here is that in the instance of redelivery, charterers have the option of where the vessel is to be redelivered.
That's at the end of the term.
At the end of the term. And we will come to clause 15 to see what that says in detail. But just to note at this point that that is not a standard term. That is the result of a negotiated term between the parties. We could easily have said a specific port, could have given a narrower range of ports, could have made it an owner's option. So I say that this, whatever is in this box, does not tell you very much about how you're supposed to construe the standard terms, in particular clause 29. And just to be clear, I don't suggest that this is a rare or unusual clause. It's perfectly usual, but so are the other options.
Should say one safe port, presumably.
Yes.
It does one safe port. Port. Yes, one safe port.
It's hard to see why the charterer's right on redelivery has much to do with the obligations of repossession and termination.
My lord, that is what I say. I say it has nothing to do with it at all. But my learned friend relies on it, so I thought I'd take it.
And I think you also say that a negotiated optional clause doesn't help at all with the interpretation of a standard clause.
Indeed, my lord. If I can then turn to clause 15, just to deal with it quickly, because your lordships have the point. It's on page 193, and that deals with the more detailed terms on redelivery.
I'll just go back a bit. Part 4 was headed hire purchase, but it wasn't a hire purchase, it was a conditional sale.
Indeed, my lord, and the part of the textbook that I didn't take you to made that point, that it was a misnomer and it's been changed in the 2017 version to purchase option rather than hire purchase agreement. Clause 15, redelivery. If I can ask you lordships to please read.
Clause 15 of these standard clauses.
Indeed, my lord, that's on page 193.
Redelivery.
Redelivery.
Yeah.
If I can ask your lordships to please read the first, the lines from 515 on the right hand side up until the very top of 524. And my lady, my lords, the point I make here, there are a few points to make here, some of which your lordships already have. The first is that this clause is only relevant if the charter party comes to its natural end. So as you will see at the expiration of the charter period, it's not relevant where there's been an early termination
Well, the charter period is, as is usual, a period, in this case 5 years, but plus or minus 2 months in charterer's option.
Indeed.
So redelivery, they have the option as to timing, and so the whole redelivery process is in a sense governed by their decisions as to the timing of redelivery. Whereas with repossession, you're talking about a moment at which there is termination.
Indeed,
Like
indeed.
very
my lord.
different exercise.
Indeed, my lord. And one of the other key points to know from clause 15 is that in the standard form, it requires charterers to provide preliminary notice of the expected date of redelivery, range of port of redelivery, or the port of place of redelivery. And in the standard form, it requires them to do so with 30 running days notice. So that means that the owners have essentially 30 days to work out what they're going to do about redelivery. As your lordship explained, termination happens at a time, so you don't have that luxury of a 30-day run-up period. The other point that is worth highlighting here is that the clause requires charterers to redeliver the vessel at a safe and ice-free port. And what that does is essentially means that the place is somewhere that the vessel can safely be, for want of a better word, repossessed by the owners safely, and it's accessible.
What does safe mean? Does that mean safe from physical dangers, or does it mean safe from states of war and the like?
My lord, the answer is probably both. Both physical safety and legal safety.
There's quite a bit of case law on
There
what's a
is.
safe port, isn't there?
Indeed, and in respect of time charterers specifically, but I'm not sure that this question has been dealt with in the charter context, but it will be physical and legal safety. And so the idea is that the owners, crew, authorised people will be able to board the vessel as is necessary at the relevant port. Final point to note about clause 15 as to why it's different, and I appreciate your lordship's already had the point, but just to make the point. What it envisages is that once charterers have redelivered the vessel to the relevant port of berth, that's the end of what they have to do. They can essentially go off on home and do all the rest of their business. That is different from clause 29, as we'll come to see, which has obligations on the charterers to essentially take reasonable care of the vessel as gratuitous bailies. So there really is no sensible way, in my submission, of looking at clause 15 as somehow indicating what ought to happen when it comes to repossession. Now, if I may ask your lordships to now turn to page 195 and 96, it's clauses 28 and 29, the real scars of the show.
Can I betray my ignorance as to what happens in practice? Charterer says, I'm going to redeliver in 30 days' time at such and such a port. What you'd expect the owner to do is make arrangements for a master and crew to take over the vessel on the date of expected redelivery.
Indeed, my
What
lord.
happens if the owner doesn't? Suppose the owner does nothing. Can the charterer just abandon the ship in the port?
My lord, that is in my submission, the answer is yes, but it's not a question that I think has been debated or ventilated at any level. So I can't tell you that is the definitive answer, but in my submission, the answer would be yes. The requirement is for you to redeliver the vessel. You have no right to possession of the vessel anymore. You've put it where you're required to put it, and it's essentially redelivery has taken place.
But redelivery suggests handing something back to somebody. If there's nobody there to take it back, can you literally just walk away? I mean, does a port allow a vessel to be tied up if there's nobody in charge of it?
I suspect the answer is you will have difficulty there, that the port won't allow you to do that. But in terms of just legally, redelivery does not require you to hand it over to someone. You can have constructive redelivery, right? Like ask me to put it in a warehouse and lock it up, and I've redelivered it to you that way, without anybody being there to collect it from you.
Okay, thank you.
Clause 28. My lords, this point probably does not go anywhere, but I just want to be clear. The judge, in his judgment, suggested that clauses 28 and 29 constitute a self-contained code. So what is to happen upon early termination? As I say, it may not go anywhere, but we disagree that it's a self-contained code. And not least because 28E, which your lordships will see on page 196, expressly says the termination of this charter shall be without prejudice to all rights accrued due between the parties prior to the date of termination and to any claim that either party may have. And that is, in my submission, wholly inconsistent with there being a self-contained code if what his lordship meant was that it's essentially an exclusive code. As I say, it may not really go anywhere. I just wanted to make that point clear. What we do agree with the judge on is that you have to read clause 28 and 29 together. Not least because clause 29, the very first line says, in the event of termination of the charter in accordance with the applicable provisions of clause 28. And so you always have to go back to clause 28 to see what clause 28 says.
I'm not quite sure I understand the point about 2018. That's just simply a judge was right. The fact that this self-contained code gives rise to a particular result is without prejudice to any other rights.
But then it wouldn't be a self-contained code, my lord. If a self-contained code, the idea is that all the parties' rights and obligations are dictated solely by that code, so you wouldn't look outside of the code.
Well, doesn't he mean it's a code for termination and repossession?
I mean, if the point is simply that 28 and 29 legislate on how the vessel is to be repossessed,
yes,
then I have no dispute about that. This is why I say it may not go anywhere, but it's just the language of self-contained code that.
I was wondering if the point is that you couldn't. Its suggestion would be that you couldn't, for example, accept a repudiation.
That would probably be wrong.
Yeah.
Yes. You would still have your common law rights available to you. I don't think that clause 28 purports to exclude those in any way.
But if there was a acceptance of a repudiation, would 29 apply? It would.
I think the answer to that will technically be no, because 29 only applies in the event.
I mean, in accordance with
Yes.
28.
Yes.
Yeah. So in other words, this probably is a self-contained code for termination, contractual termination.
For contractual termination, perhaps, and I perhaps don't need to get into that detail, but
I don't think it really doesn't seem to help.
I don't think it does, my lord. I just wanted to make the point clear. So turning to 28, what 28 does set out 5 circumstances in which the charter can come to an early end. 28A, and I don't think I'm going to ask your lordships to read all of 28, but what 28A does is entitle owners to terminate in the event of charterer's default. And charterer's default essentially includes the failure of charterers to pay hire, the failure of charterers to maintain the vessel or to keep it in good repair, the breach of trading restrictions, the failure to insure the vessel, the failure to, as I said, repair the vessel. In those circumstances, owners have the right to terminate. 28B owner's default. And as your lordships will remember, I made the point at the beginning that owners have very limited obligations, save for the obligation not to disturb the quiet use, enjoyment, and possession of the vessel. And that point is brought home by 28B, because it entitles charterers to terminate where there's been a breach to the extent that charterers are deprived of the use of the vessel. And such breach continues for 14 days.
What is that contemplating? When might that in practice occur?
Perhaps, my lord, if I, as the owner, mortgage the vessel
And failed to pay the mortgage.
and fail to pay the mortgage, and so
The mortgagee could take possession.
indeed, and so in that situation, I would have breached my duty. But that goes to the point that I would like to make about 28B, which is that given the limited nature of the obligations on owners, and the fact that charterers are in possession of the vessel, it follows logically that you are going to have substantially fewer examples of cases where charterers are terminating for owner's default compared with owners terminating for charterers default. Because charterers, logically, the number of opportunities for charterers to default are substantially more than for owners.
Thank you.
Then 28C, which deems the charge party terminated where there is a total loss of the vessel. And total loss in two senses. One is where there's been an actual loss of the vessel, and the second is where there's been a constructive loss of the vessel, but a constructive total loss that has been agreed to by the insurers or has been adjudged to be the case by a competent tribunal. Now, the point I would make about this part is it is unlikely that this is a... Well, I'll start here, my lord and my lady. If there's been an actual total loss of the vessel, by definition, it can't be repossessed. It's a vessel probably at the bottom of the sea somewhere, and nobody can repossess it. That's why it becomes an actual total loss. If it's a constructive total loss, it may be possible to repossess it, depending on the nature of the constructive total loss. Again, if it's a vessel that's stuck at the bottom of the ocean, that is possible to repossess, but it's just uneconomic to do so, there wouldn't be any repossession. But if it's something where the vessel is just in disrepair, but it would be too expensive to repair it, it may be possible to repossess it. But what I say is that it is unlikely that that is a central focus of the draftspeople when considering repossession, or how the vessel will be repossessed. But they were thinking of a scenario where 28C had been triggered. And then there's 28D, which has two bases for termination in it. If the charterers are insolvent or have entered into what we've described as insolvency adjacent proceedings. And then on the other side is if owners are insolvent or have entered into insolvency adjacent proceedings. Now in this case, the owner's part is extended to owner's parent company, which is a guarantor, but it doesn't change anything really about the construction of 28 and 29. Now, I think your lordships probably already have this point, but when there's been a termination pursuant to clause 28, it's unpredictable when that might happen. The vessel could be at port, loading cargo, at port discharging cargo. It could be at sea, in ballast or laden. It could be under arrest somewhere. Lots of innumerable scenarios where the vessel could be. And the idea is that unlike redelivery, where the owners will have 30 or 20 days to be able to work out how to take redelivery, there is no time between termination and when the right to repossess the vessel arises. And what happens at that point in my submission is that charterers cease to have any rights at all to possess the vessel for their own use. That's what happens immediately upon termination. Because the only basis upon which you're entitled to use that vessel is the charge party. The charge party has come to an end, that right disappears. And on the other side of it is that owners have the right to repossess their vessel because the vessel belongs to them and they pay laws for this. But all of this will have to happen in potentially difficult circumstances, vessels at sea, vessels in a very distant port. And unless you have an agreement that deals with how that's supposed to work, there are real practical difficulties that could arise. And that's what Clause 29 attempts to do. Now, what I intend to do on Clause 29 is go through it essentially sentence by sentence. But before I do that, just a high-level summary or overview of how I say the clause works. I say that the first sentence of the clause, what it does is it tells you where repossession is supposed to take place. And then we jump to the third sentence, which I say tells you when repossession is supposed to take place. The fourth sentence tells you how repossession is supposed to take place. And then the second sentence, going backwards, tells you what is to happen in the interregnum between termination of the charter and the physical repossession of the vessel. And then the fifth sentence I'll describe as miscellaneous, but that deals with costs relating to the crew, master, and officers of the vessel. So in the sense that the clause, each sentence has a role that it's playing in the general scheme of Clause 29.
You agree that you should try and read those aspects of the clause together?
Absolutely, absolutely. But and I say that on my construction you can do that, but it's just important to understand that you must also give each sentence, I say content, because each sentence is there to serve a particular purpose. You can't just use the third to gut the first of any meaning or content. So the first sentence, my lady and my lords, I might just read that out. I'm sure your lordships have read this probably 100 times. In the event of the termination of this charter, in accordance with the applicable provisions of Clause 28, the owners shall have the right to repossess the vessel from charterers at a current or next port of call, or at a place or port of place convenient to them, without hindrance or interference by charterers, courts, local authorities. The first part is, we've dealt with earlier, triggers. Clause 29 is triggered when there's been a termination in accordance with Clause 28. So the next part, which I say is very important, is what the clause does is that it confers onto owners a right.
But the right is only to repossess, isn't it?
My lord, we would disagree with that because the owners already have the right to repossess. The vessel belongs to them and the charter party has already come to an end. It is their vessel, so they can repossess the vessel. The right is to repossess it at, I say, one of three places. The current port, the next port, or a port or place convenient to owners.
Looking at those three places, as you say, the vessel, as you say, is going to be in a port, or it might be on the high seas in various conditions. Current port envisages obviously that she is currently in port.
Indeed.
Now, subject to some unusual circumstances, if she's currently in port, then the obligation to put an authorised representative as soon as reasonably practicable upon following termination, why doesn't that arise at the current port?
That begs the question of whether or not the obligation is to take it at the that sort of answers the question that we're trying to deal with here. Because if I have a right to select, then the obligation to place somebody on board of the vessel would be at the place where I need to repossess the vessel. So if I elect, for example, to do it at the next port, the obligation to place somebody on board the vessel would need to happen at the next port.
But that's not what the clause provides, does it? That the obligation to arrange for someone to board the vessel is not stated to only arise when when the vessel has reached a current next or at a port or place convenient. You have to read those two clauses together, two sentences together, don't you, to understand which of those options is applicable in a particular case.
My lord, we would say that that is not the way to do it. So, importantly, what the third sentence does is not to require the owners to take delivery of the vessel at a particular port. It says to take repossession of the vessel as soon as is reasonably practical.
Well, following the termination of the charter, not
Indeed.
following the voyage to some other port.
Yes, but the point is, in order to be able to, reasonable practicability is clearly an elastic concept. It's not the same as saying you have to do it as soon as possible. And if that's what was required, that is what would be said there. And when you are considering what is reasonably practicable for the owners to do, necessarily one has to ask, where is it that where is the place of repossession? The third sentence doesn't dictate where the place of repossession is.
Why not?
Because it's
Given it's an obligation to do it as soon as reasonably practical after termination, why can't you read that together with those options to say, it seems to me you can read this quite sensibly. If she's in a port, then you can put someone on board in that port. If she's on the high seas, then what is her next port? And the next port is her next port on her scheduled travels. But obviously, if next port is a long way away or inconvenient, you can say rather than having to sail to New Zealand, please will you call in at the next convenient port, which is say Suez, and that all makes perfect sense, doesn't it? What it doesn't enable you to say is, although we've got to put someone on as soon as reasonably practicable, we would actually like you to go on a journey of many thousands of miles to a port which we say we find more convenient.
I don't suggest that is what the clause allows you to do. So, there are 2 points to do. First of all, if I can just show you the commentary on the purpose of clause 29. The reason I want to show you that is that one of the concerns is that the vessel might be at a distant port when the termination occurs.
Distant from what?
Distant, presumably from the owners or from perhaps general commerce. But as we discussed, the vessel can be anywhere in the world at the time of termination because the charters have complete control of it. And so one of the purposes of clause 29 is to be able to deal with that.
How does this arise? I mean, you can authorise a representative at any port to go on board the vessel. You don't need to fly somebody from Croatia to the west coast of the US to go on board the vessel.
Well, in real terms, you can, depending on where it is, you can find somebody within the jurisdiction, contract with them to be able to go on board the vessel. The question is whether or not you're going to be able to do that.
Is that difficult in practice? I mean, I understood that there were agents who provided masters and crew at short notice. Am I wrong about that?
I'm certain that it is possible, but the amount of time that it would take a particular owner to do so, I can't tell you. For some people, it's probably very simple to do. If I was a ship operating company, for example, it's probably easier for me to just fly my people out there and take a matter of hours. If I'm not, I may have to contract with someone. How quickly can I contract with someone, and how quickly can they get people on board there? It's just a matter of a question of fact, which may or may not be easy.
Presumably, this clause 29 was drafted very firmly with practicalities in mind.
Yes, my lady.
So it wouldn't have included, as part of sentence 3, arrange for an authorised representative to board the vessel as soon as reasonably practical. If the general rule was it is practical to get people to various ports around the world when the situation arises.
My lady, can you please repeat that?
Sorry, I'm not being very clear. I just think that they would have had the practicalities that my lord has just raised firmly in mind when they were designing clause 29.
They would, my lady, and it is clear that the drafts people envisaged that could take time, which is why you have the second sentence about the vessel being held as gratuitous payee.
Well, no, I mean, even if it only takes 20 minutes, you've still got to deal with what's the status of the charterers in that 20 minutes.
But it may take
Sorry, I interrupted you. If you're on the high seas, then even if you're going to be in port the next day, there's going to be a gap between the point of termination and the point at which it could be physically repossessed, even if the owner has a master and crew ready, willing, standing ready to take over as soon as possible. They still have to wait for it to come in. They're not going to helicopter the crew out in the middle of the voyage, are they?
I know. It may be possible, but I don't need to say that it is possible. I appreciate that there will be time if the vessel's in the high seas that is required to get the vessel to a port. If the vessel's already in a port, it may take 20 minutes to get someone on board, and yes, there is a time lag there, and perhaps that's what this is dealing with. This is part of what this is dealing with, but it can't be the only thing that it is dealing with. And my lord, can I just show you?
Pending physical repossession plainly deals with the period until the owner shall arrange for an authorised representative to board the vessel as soon as reasonably practicable. So you would, as the owner is obliged to do that as soon as reasonably practicable, you would assume that that period would be relatively short.
My lord, that's the problem. That assumption, I submit, does not necessarily follow. It depends on several things, including where the vessel is. If the vessel is somewhere in New Zealand, and I am, for example, in clause 28D territory, where we work in this case, for example, I'm the owner of the vessel and I'm insolvent. When assessing what is reasonably practicable from my perspective, you have to consider where the vessel is and my own situation, because you're looking at it with reasonable practicability of the owners. So while it may be in theory possible for one person to be able to get someone on board in New Zealand in 20 minutes from Croatia,
where you are in Croatia seems to me to be relatively irrelevant, isn't it? Because you are not personally going to be the master or crew this vessel. You're going to have professionals to do it, and it'll be a matter of if it's in New Zealand, you probably would have you presumably be able to find a master and or a crew there, or if not, you'd fly them there from Singapore or from whatever. I mean, it's not a problem. And if you don't have the skills to arrange that, you would pick up the phone to a relevant agency that does. And these are vessels that are crisscrossing the world and it's not a matter that it has to be brought back to Croatia in order for you to repossess it.
Oh, my lord, I think there is some miscommunication between all of us going on here. I don't suggest that the effect of Clause 29 is to always require, and this is the point perhaps that your lordships have taken from the respondent's argument, which is not an accurate version of how I say Clause 29 works. It does not require or entitle the owners to elect the place most convenient to them wherever it is in the world. That is not the argument I'm making, and that is clearly not what the tribunal found. It entitles you to elect a convenient place, but there are two guardrails on that, as the tribunal found, and I'll show you to that, my lord, my lady. The first is that it has to be convenient objectively for the purposes of repossession from owner's perspective. And secondly, it cannot be an irrational, arbitrary, and I would say unreasonable election of a convenient place. What the tribunal says, and I agree respectfully, that when you're assessing what is a convenient place, one of the factors that you have to bear in mind is the obligation, or they don't put it in terms of the obligation, but the express intention of the parties that the repossession is done as soon as possible, as soon as reasonably practical.
Why is that not an obligation? It is an obligation, isn't it? The third sentence imposes an obligation.
The third sentence imposes an obligation, and the point is that it manifests itself, is probably the way to put it, in two possible ways. One is that when I'm deciding what is a convenient place, I've got to bear that in mind. I can't choose somewhere in New Zealand because I'm based in New Zealand, even though I could easily have repossessed a vessel in Istanbul, for example. But also, it means that when the vessel gets to the place for repossession that I've elected, I must have an authorised person on board the vessel as soon as reasonably practical. And so
once you say you have to bear in mind the obligation in the third sentence when choosing a port that is convenient to you, why does that not collapse into the proposition that the port that is convenient to you is the port at which you can first reasonably, practicably put someone on board?
Because, my lord, and this answers to some extent also the point of my lord, Lord Justice Phillips makes to me, is that is a way in which someone could have drafted a repossession clause. That is not the language, that is not the ordinary meaning of the language that is used here.
Well, I understand that, and I understand we wouldn't be here. It's usually the case with contractual disputes. It would have been drafted more clearly. And it could have said expressly what you've just said. But I understood you to say the third sentence imposes an obligation on the owners, and the owners don't have a free hand in nominating any port in the world. They have to bear in mind that obligation when choosing a port convenient to them. I understand that. But let's bring it home to this case. If they could reasonably, practicably put on board a representative in Stockton, California, and they have to have that obligation in mind when choosing a convenient place to them, why are they not obliged to choose Stockton as being the most convenient place? How can they say, well, I know we could do it in Stockton, and we could do it in Mexico, we could do it in Gibraltar, but the convenient place for us is Croatia, Trogir in Croatia. That seems not to require them to bear in mind where it's reasonably practical to do it first.
There is a chance we might be having a dispute in this case about a different point. Because it ultimately, if you look at the facts of this case, and I will try and take a lordship to what the tribunal find, because this might answer everything you're asking in clearer terms. Owners are a shipyard, so they need a third party to be able to assist them. That's point one. Point two, they're insolvent. So for them to be able to hire the third party is not simply a matter of me making a call to somebody and they'll have someone there immediately. It's going to take probably a lot more time.
That's going to be the case wherever. It's
Quite. And so if the obligation or the point to bear in mind is that I have an obligation to repossess the vessel as soon as reasonably practicable, and this is the point the tribunal are making, it's actually, they say that it wasn't proved that charter owners would be able to repossess the vessel at Stockton any quicker than they would if the vessel sailed to Tregear. I will take the judges to that if that's what they like.
My lord, my ladies, may I intervene very, very briefly? There are simply 2 points which I would ask my learned friend to reconsider. One is the allegation that owners were insolvent, and there's no finding to that effect, and I don't recall it was ever alleged that at this stage the owners were insolvent. The other is the precise terms, again, of the finding by the tribunal, which I will submit has not been accurately summarised by my learned friend there. Apologies for interrupting.
Well, I think you were going to take us to the tribunal in any event. And do you accept they weren't actually technically insolvent? They were busy restructuring, I think.
There were the owners. The way the tribunal put it is the owners were an SPV owned by the yard British Tregear, who were in insolvency proceedings and suffering financial difficulty. So I'll just take you to that. It is tab 6,
Thank you.
page 142. So what I'm going to do, my lady, is just show you, first of all, the way the tribunal say you construe the provision, bearing in mind the reasonable, as soon as reasonably practical sentence, and then how the tribunal deals with it on the facts. So 125 to 127.
Yes, so how far are you wanting us to read?
Just to 127. And so 125, the tribunal says that what is convenient has to be viewed objectively and cannot be wholly extraneous from the purpose of prompt delivery. I beg your pardon, from prompt possession.
Sorry, where are you reading?
125. That's page 152. And then at 126, the tribunal say it is correct, you have to read the first and the third sentences together, but you don't have to read the third sentence in a way that essentially guts the first sentence, I submit, because it says you don't have to, it doesn't impose an obligation requiring owners to possess as soon as practical, regardless of whether a case was convenient to them. And then at 127, and this is the point I was making earlier, the second sentence, the convenience of a place is to be assessed objectively against the party's express intention for the vessels to be repossessed as soon as reasonably practicable. Time by which owners could reasonably arrange to take actual possession of the vessel would be a relevant consideration in determining whether a place is convenient. So that is something, as I say, one bears in mind when assessing convenience. And so, one turns to page 145, which is how they deal with the facts. I'm starting at paragraph 135 to 137.
I think you look at 134, not disputed that the voyage to Nugee would have taken well over 37 days, cost at least $500,000.
Indeed, the point is made again.
What's wrong with the first sentence of 135? It would have been reasonably practical for owners to repossess the vessel in Stockton.
The obligation, my lord, is not to take the vessel, to repossess the vessel at the place that would be reasonably practical to do so. The obligation is to repossess the vessel as soon as reasonably practical after termination. So it's really about timing.
And your only obligation, the only obligation imposed on you in clause 29 is in the third sentence.
Indeed.
The first sentence only gives you a right.
Indeed.
And what it says is you have the right to possess it in any of these three places.
Indeed, my lord.
But then you have the obligation to do it as soon as reasonably practical. So if that obligation requires you to do it, and you can do it at the current port, then why aren't you obliged to do so?
Take the example, my lord, the answer in this case is in 135 to 137. But a simpler way of looking at it is this. Say it is going to take me 30 days. Because if one looks at the redelivery provision, for example, it is clear that BIMCO understand there is going to be time required for owners to be able to take their vessel. That's why you need 30 days notice. If one looks at this case, it might take, let's say, 50 days, and I'm just throwing numbers out there, 50 days for me to be able to contract with somebody, wherever the vessel is in the world, because I'm an SPV, my parent company is a shipyard that is going through financial difficulties. So it's going to take me some time.
Forgive me, I don't think the 30 days notice of redelivery is so that you can arrange to take repossession. It's so that within that sphere of 4 months during which the charterer can redeliver, you know when in that 3 months you're going to get the vessel back so that you can recharter it or do whatever else you want to do with it.
No, Mother, that's to read the standard terms by reference to the specific that was actually the negotiated terms. The charter period could just say 5 years.
Well, it could, but they almost invariably don't, because it's not such a precise science, is it?
But if you look at what the notice requires, it requires timing, estimate timing, but it also requires them to tell me when. Sorry, where, I beg your pardon. And part of the reason for
It's
that...
a sensible, orderly ending of a contractual relationship, isn't it? You know that it's going to be terminate in this period, and the charterer says, here's my 30-day notice, that I'm going to redeliver it in Stockton, California. But here we're talking about the unstructured sudden demise of the demise, and at that point, as it were, it's all hands on deck, so to speak, and you've got to send someone as soon as you can to take possession, because as you say, you now have legal possession of you have immediate right to possession of the ship. The charterer no longer has any right to be there, is only there as a gratuitous bailee, and you're obliged to take it as soon as possible.
I don't,
So it's practicable, sorry.
that seems to be part of what is infecting the argument here in my submission. The obligation in my submission, one must bear in mind that it reasonably practicable really is very different from as soon as possible. And reasonably practicable must, in my submission, include a consideration of my position at the time of termination. And in this case, as I said earlier, to be absolutely accurate, the finding is that the owners were an SPV owned by Brother Trogia, which was a yard, and in financial difficulty and insolvency proceedings. So one has to bear what is reasonably practicable time-wise in that context. You also have to bear that in mind as to where the vessel is at the time. And so as I was saying with my example, if it was going to take, there is another assumption in the question from your lordship, which I would urge you not to make, because it may be true in some cases, it just does not follow that it is always correct, that it is always quick and easy to get a third party on board a vessel. There is no doubt that there are cases where that is the case, but BIMCO is clearly drafting standard terms that will apply in a wide range of cases, and it is impossible to be able to say exactly how long that exercise will take. And as I said, this is a point that's made in Begging Charterers. One of the concerns that is being addressed by Clause 29 is that the vessel is at a distant port when the charter is terminated. And so it will still be in port, but the port will be a distant place. And if what 29 is trying to do is to deal with that, it can't just be assuming that, well, you can stick someone on board in 20 minutes or a day. It may be the case in some cases, but in other cases it may take much longer, like it could have taken in this case.
What about Stockton, California? I can't imagine it's very difficult to put a master on board in Stockton, California.
I know there are two answers to that. One is, just as a matter of guesswork, it probably is not too difficult to put someone on board in California. But this was also, and these are the 2 points. One, this was in May 2021, so we're in COVID times. And so as the tribunal found, while it was reasonably practicable to put somebody on board, there was no discussion about timing. And then the second point is that as the tribunal saw it, the onus, I submit, is on the charterers to prove essentially that the vessel could have been repossessed quicker in Stockton than it would have been on a voyage to Trujillo. And that, but they were unsatisfied based on the lack of evidence before.
The proposition I have difficulty with, I have to say, is paragraph 136 of the arbitrator's decision, where they say the mere fact that it might have taken up to 2 months to reach Trujillo did not render it inconvenient for the purposes of clause 29.
My lord,
So it's exceptionally inconvenient to require the charterers to sail the vessel as gratuitous bailees for 2 months.
my lord, it was found, in fact, that it was going to take no more than, so if you follow the sentence all the way through, the voyage should take no more than 45 days, and that may not soften your concern. But then the next sentence, the next 2 sentences are the important one. The point is that, well, it may take 45 days to sail this vessel to Trujillo, but there's a chance that it could have taken a substantial amount of time for us to be able to put somebody on board in the vessel in the first place. So, in actual fact, it is possible that it is going to be quicker for you to sail the vessel to Trujillo than us, in our current state, basically fail to be able to get somebody on board because of the financial difficulties they're going through.
Was there evidence about that?
There was, and this is the point, there was no evidence on the timing. The tribunal simply say they could reasonably have taken a substantial period given neither owners.
So you're saying timing was at the heart of this, and yet there was no evidence about it.
It's difficult to remember how exactly the arbitration transpired. Certainly, there is no challenge to the tribunal's factual position in this case, and in fact, it can't be challenged.
Understood.
Is the fact that you're in financial difficulties, the yard's in financial difficulties, relevant to an assessment of how soon it's reasonably practicable to put a representative on board?
I know this is the point I tried to make to you earlier, which is what I think that that may be where the debate gets to, which is different from the way the debate has transpired at any point, which is our financial position a relevant factor when assessing what is reasonably practical?
Yes,
It
because
must-
in general, the fact that a contracting party doesn't have the money to comply with its obligations doesn't change its obligations.
That would be the case if my obligation was to repossess the vessel tomorrow.
Yes.
The question is, if the parties say that it's as soon as reasonably practical, can we take into account my financial position? In my submission, you must be able to, because, especially if one reads clause 29 as a whole, the question is about what is convenient to owners or for owners. And so you have to consider owners' position, including its financial position. One way of looking at it, and I accept it's an imperfect analogy, is like the reasonable endeavours provisions, which don't require the person who is obliged to exercise reasonable endeavours to act against its own financial interests. I would say that reasonably practicability, I beg your pardon, is a concept that necessarily is flexible and elastic. The factors you can or will have to consider will change from case to case. And in this case, owners' financial position or the ability of owners to be able to put somebody there, the practical ability of owners to be able to put an authorised representative on board the vessel must be a relevant factor.
Thank you.
Right.
The arbitrator said in 137, not satisfied that it would have been reasonably practical for owners to have taken repossession of the vessel on the 14th of May or shortly thereafter. I mean, presumably you say that's a finding of fact.
Indeed, I say there are two findings there that are unchallenged and unchallengeable. One, that essentially there is no, that it was not reasonably practicable for owners to have taken repossession of the vessel on 14 May 2021 or shortly thereafter. And the second finding is that, pregnant in that, is that the burden is on owners to satisfy the tribunal.
Do you mean owners?
I beg your pardon, my lord. Charterers, the burden was on charterers to satisfy the tribunal that it was possible to do so sooner. And that also follows because what charterers are trying to establish, or insofar as it's relevant here, is a breach of clause 29. So they're saying, well, you're obliged to do something as soon as reasonably practicable. You fail to do so, and the obligation is on them to prove the breach.
They're not saying it wasn't reasonably practical for you to do it at all, just you couldn't have done it by the 14th of May or shortly thereafter. Indeed,
And in fact, to the first point, they specifically say it is reasonably practicable for us to have taken repossession at Stockton.
Yeah.
Question is about timing. Because if the focus is to be on the third sentence, then in my submission it needs to be all of the third sentence, which is not just about whether or not something is reasonably practicable or possible. It's about the timing. So the third sentence deals with when. And what the tribunal is saying here is you've not established that this could have been done quicker than sailing the vessel to Trogir. In my submission, once one understands what the tribunal is doing here, it's clear that nobody is suggesting that the owners are entitled to require repossession at any port in the world, no matter where it is, no matter how long it's going to take to get there. The point here is that Trogir is a place that is convenient, and in assessing convenience, there's a place that the charterers had not established would take longer to repossess the vessel than in Stockton.
Can we just try again, looking at the first sentence, see whether I can understand this?
First sentence
Of 29. Now this is providing where you have a right to repossess. Current port is perfectly straightforward. If the vessel is in port, you have the right to repossess there. Now, next port means the next port on its scheduled voyages, presumably.
Indeed.
And of course, that makes sense if it is at sea, heading for port.
Yeah, my lord.
But if it is in port, next port doesn't make sense because the charter's been terminated.
Not unless, if I say, bearing in mind the guardrails of rationality, caprice, and the fact that I'm bearing in mind my obligation to repossess the vessel as soon as possible, that it's actually quicker for me to repossess the vessel at Trogir than at Stockton in the example, because it will take me forever to, Trogir being your next port in this example, it will take me forever to be able to get somebody to board the vessel
What is missing, surely, from this is any obligation on the charterer to sail the vessel to another port.
My lord, it does not expressly articulate an obligation to sail the vessel, but it is necessarily implicit in it. Even if one looks at it as in the simplest case, which if you were rewriting this, you could say, while the vessel is at sea and the charter is terminated, the repossession is to take place at the next port, and the next port could be a transoceanic voyage.
Well,
there is an obligation in that case, implicit in it, for the charterers, while acting as gratuitous bailey, to sail the vessel to that port.
well, the vessel's plainly got to sail somewhere. I suppose it could just...
It could find the
It could be
closest
station.
place and just put in there.
But isn't the intention here? It seems to me the intention is that if it's at a current port, you have the right to possess there, and you have the obligation to do so as soon as reasonably practicable. If it's at sea, it goes to the next port where you have the right and the same obligation. But rather than having to sail to the next port, which may be far distance, you can say it's more convenient for you to call in to this port, and then you have the right and the obligation. And it seems to me that's a quite straightforward reading of the clause, isn't it?
My lord, what I would submit is that is a clause that would work, but in my submission that is not the language that is used here. It doesn't give effect to the ordinary meaning of the language that is used here, and it is essentially rewrites in my submission, clause 29, because first of all, in my submission, one has to give effect to the fact that what is being conferred here is a right, and it can't just be the right to repossess, because that is something I have already. Then you've got the disjunctive or between current or next port or port of place convenient to that. I think what your lordship is suggesting the way clause 29 would be read, it would need to say is entitled or is put into one side the fact that it would be changing everything to an obligation rather than a right, is that the vessel is to be repossessed at her current port if in port, and if at sea, at the next port of call, or at owner's option, a port or place convenient to them. But that just is not what the clause says.
Well, we've got to make sense of it, reading that clause with the obligation on your clients. What seems to me, what it certainly doesn't say is that even though you're at port, the charterer has an obligation to sail the vessel to a port convenient to the owners. And I mean, I don't know if you can show us any authority for the supporting the view that a party who no longer has any legal possession other than as a jus bailee has to undertake a trans-ocean voyage at its own cost of some 45 days, whilst the owners all the meantime have an obligation to take possession as soon as reasonably practical. It just seems to be reading an awful lot into a simple provision about your obligation to take possession.
Well, there is no authority on this point on construing this clause. But in my submission, your Lordship's problem with the clause, or the way I read the clause, is in my submission because it already presumes the answer. If the question is, what does the first clause say? And in my submission, the clause necessarily envisages the vessel or charterer is being required to sail the vessel to the next port. On the simplest case, vessels at sea, the only way that the vessel can be repossessed to the next port is if charterers, which are just bailees, sail the vessel to that port. They're going to have to do so at their own upfront costs. And in my submission, nobody is suggesting that owners aren't required to make good the upfront costs to charterers. Those would be costs of the gratuitous bailment, and they'll be entitled to repayment of that cost from the owners. So if the clause already necessarily envisages a possible transoceanic voyage to the next port, there is nothing remarkable that it could also envisage that in respect of a different particular port that is a convenient port for owners.
I think there's a big difference between being at sea and saying sail to the next port or call in somewhere else, and saying you are at anchor or berthed at a current port and you have to set sail to somewhere new. That seems to be something quite different.
My lady wants to.
Sorry to interrupt, but we're just going to rise for 5 minutes or so.
Rise if you're
Nothing to do with your submissions, I have said that.
Just to let you know, we've risen for just 5 minutes, the live streaming will still be running. Court rise, if you're able.
Equality on all sides. We'll be doing the same this afternoon. Yes, now where had we got to?
I think my Justice Phillips said it was a different thing to require the vessel to sail from sea to the next port to asking a vessel that's already in port to sail to another port. And the answer to that is that yes, it is a different thing, but ultimately, if what the clause is trying to do is to get the vessel repossessed most efficiently, is when you are considering, you have to bear in mind the convenience of being able to repossess the vessel. And if, while the vessel is at anchorage, all it is going to do is sit there for a period of 50 days, because owners are not in a position to recover the vessel, then all that is happening is that charterers are continuing to incur costs, maintenance costs, crewing costs, insurance costs, while the vessel is sat at anchorage. If you read the clause in a way that gives owners an option, and that option is informed by their obligation under 3, it means that they're actually able to get the vessel repossessed sooner, in my example, where it would take 35 days to sail, whereas it would take 50 days for me to try and get somebody on board the vessel. And so you can't have a broad brush rule that if the vessel is in a particular place, it must necessarily follow that it is going to be quicker or more reasonably practical to get the vessel there. And what clause 29 does is to allow that optionality to exist. But what it does is that it places the option in the hands of owners, not in the hands of charterers.
I understand your case that if it's quicker to sail it to Croatia than to leave it in California, given the difficulties you have in mustering a crew, then the owners could require it to be sailed to to Croatia. But suppose the evidence were that you could get a crew on board in California within a few days, could you still require them to sail it to Croatia on the basis that's more convenient for you?
The answer to that will depend on. So the way I would say that the one answer is that based on the tribunal's approach, which we command on your lordships, is that you would ask if me selecting Tregear, which would take 45 days, rather than Stockton, which would take 2 days, is an irrational, unreasonable choice. And the answer, I'm bearing in mind that the intention of the parties that the vessel is to be repossessed as soon as is reasonably practical. Now, the answer to that may be yes, that would amount to an inconvenient place because it's irrational, arbitrary, unreasonable to select somewhere that will take 45 days rather than 2 days. But that is not the situation we have here. And so the concerns that your lordships have, in my submission, is dealt with by the guardrails of it having to be objectively convenient for the purpose of repossession, but also that the election can't be irrational, arbitrary, unreasonable.
Let me just be clear. The obligation isn't to put a crew on board. It's just to put on an authorised representative.
Indeed.
That's how you take possession.
Yes, but there is then a question as to and to some extent the debate is relevant because of the way it plays out in the case. But me putting an authorised representative on board does not, on one view, amount to the physical repossession of the vessel. And on one view, what the clause does is that it draws a distinction between 2 types of possession and repossession. So if you look at the fourth sentence, repossession is deemed to have taken place when the authorised representative boards the vessel. And then it then says, in the second sentence, pending physical repossession of the vessel, the charter is a gratuitous bailey. So on one view, there is, yes, while I put the authorised person on board, I can't really do too much about it. When the vessel is crewed, essentially, that's when it's physically repossessed.
No, I don't think that's right.
Can't be right.
I think it's when the authorised representative goes on board, and then it says deemed repossessed charters.
Yes, and that's the point I'm making. My note. As I say, one way of looking at it is that it is drawing a distinction between a deeming repossession and an actual physical repossession. But in the end, it probably doesn't matter too much because
It's physical repossession in accordance with this clause 29. That must be the putting your authorised representative on board. There's nothing else in clause 29.
Yes, Mano, that must be right. That must be right. But the point still, like, if I just take a moment back to the Lordship's question, it is that me putting an authorised person on board does not require me to put a crew on board. And that is correct, but it is difficult to see in practice that somebody is just going to send one person to board a vessel, rather than at least a cluster of people to be able to board the vessel and take care of it.
Well, that's your problem, isn't it?
I mean, you're saying. I'm sorry.
Yes, no.
I mean, you're saying it's the charterer's problem to find the money to embark on a voyage of 45 days, knowing that you're in big financial trouble. So surely it's your problem to worry about whether you've got enough people in addition to the representative.
That my argument does not need there to be a requirement to have multiple people on board. Even if it takes one person, one authorised person to board the vessel, it's still a point that it may take a day, may take 45 days, may take 50 days.
You could presumably engage the existing masters and crew.
My lord, practically, I don't know how feasible that is in reality. So it begs the question of who has to pay them. It's possible. I don't.
Well, once you engage them, you pay them.
Yes, but then it may be that the master and crew are actually employed by the charterers. So yeah,
They could
it's
be.
possible.
The master may not be. I don't know. Anyway, there are various possibilities here,
and to the point about the charterers having, and this seems to be one of the big concerns that drove the judge at first instance to the decision he reached, and is that the charterers will have to sail the vessel at their own cost, notwithstanding the fact that owners are in financial difficulty. But in my submission, that risk, that credit risk, let's call it that, is inherently baked in to clause 29. Because if, to take my example, the vessel is stuck at anchorage and I need to get somebody to board the vessel and it's going to take me time, owners have to continue, I beg your pardon, charterers have to continue to take care of the vessel.
But they only have to take care of it. They don't have to sail it.
Yes, but it's going to cost them money to crew the vessel, to leave it insured, to repair it if any issues come up.
Do they have to insure it?
Once,
no, plainly not.
no, not once it's been
Once it's
terminated.
The obligation to insure is over, and they're just gratuitous bailey.
So be it. Then they would still have to crew the vessel and keep it in, essentially maintain it and take reasonable care.
And your client would be very well advised to take out insurance immediately.
That would be correct if charterers don't have to insure it. But then the other point is that it's also baked in if one takes the example that I think everybody is happy to assume does arise under clause 29, if they have to sail the vessel while it's at sea to the next port. Again, it's going to cost you bunkers, you're going to have to man and crew the vessel, you're going to have to maintain it, and in that case you're probably going to have to keep the insurance in play. That's still going to cost them money, and because 28D gives them a right to terminate when I'm an insolvent company or in some sort of insolvency adjacent proceedings. That
Well, that's why a charterer is almost certainly going to terminate when it's in a port.
But the right isn't just for the charterers
Exactly.
to terminate.
As far as the owners are concerned, they probably have the same incentive, don't they?
The incentive being what, my lord?
To do it when it's in port. Because otherwise it's at sea, unchartered.
But if the obligation, it begs the question of what 29, the first clause, first sentence does. Because if it requires charterers to sail the vessel to the next port, then I don't have that concern. Vessel I have terminated the high seas and the vessel's got to go to the next port at a minimum. Put into
Not
what?
accepting that you're obliged to pay the cost.
Yes. And it may be that is something that makes more sense to me. That's a decision I've got to make on my side as to when I'm ready to terminate. In fact, my lord, I beg your pardon. If one looks at, so I think you actually have to act quickly if you want to terminate for the purposes of non-payment of hire. So it's not something that I can just sit on and make a decision about. Just to make sure that it's accurate. There's nothing in the clause itself. I think the principle there is that I've got a reasonable amount of time to exercise my right. Otherwise, I might be seen as having waived the right to withdraw the vessel to non-payment of hire.
Okay.
So it's not something that I can just sort of sit on for a period of time until the vessel gets to the next port.
Okay, well, I don't think we need to tackle that point. I think we've got enough to be thinking about. Now, where have we got to?
I think we've probably addressed a lot of the points in between all the discussion. What I say is that, just to recap, it is important to give effect to the ordinary meaning of the first sentence. In my submission, you have to give effect to the fact that it is a right that is being conferred onto owners. In my submission, it can't just be a right to repossess because that is inherent in the situation.
Thank you.
And to give it content, it's got to be a right to elect one of the three places. When it comes to the convenience point, I agree with the tribunal's guardrails, as I've called it, that it's got to be a matter of convenience for repossessing the vessel, and it can't be irrational, arbitrary, or unreasonable.
Thank you. It's very clear.
The second sentence in my submission does not advance matters because while it is clear as a matter of common law that the gratuitous bailee does not have an obligation to redeliver a chattel, the authorities were also clear that that can be modified by contract. And so what that does is it just begs the question of whether or not clause 29 does modify the common law position. So you end up again trying to construe the first sentence. And in my submission, it is important, critically, that the first sentence of clause 29 generally envisages the vessel being sailed to the next port while the charterer is a gratuitous bailee. So that already necessarily modifies the position. So it doesn't go anywhere. The clause 2, the second sentence. The third sentence we've debated about, my lady and my lords.
We've got your position on that.
The fifth sentence, if I may just say a quick word on that, my learned friend says, so the fifth sentence is the one that says, all arrangements and expenses relating to the settling of wages, disembarkation, repatriation of charterers, masters, officers and crew shall be sole responsibility of the charterers. And my learned friend says, oh well, that deals with essentially the allocation of costs. And if it was envisaged that charterers would incur substantial upfront costs, then that would have been dealt with in the fifth sentence. Well, I say that just does not work, again, because well, two reasons. One, all that the fifth sentence is dealing with is costs of the crew, essentially. We call masters officers, let's just call them the crew. And the reason it deals with that is because if the crew aren't paid, the vessel becomes at risk of arrest. The sentence is not dealing with costs more generally. And you can see that it is not dealing with the cost of sailing the vessel to the next port. And in my submission, there can be no real debate that the clause envisages the vessel being sailed to the next port of charter as upfront cost. So the fifth sentence really doesn't move matters at all.
Can I just explore it a bit? But take a case where the vessel at the point of termination is on the high seas and is sailing for a port which the owners are happy to repossess at that port. So there's no question about an argument as to where it's going to be repossessed. It's quite clear from the second sentence that the charterers are gratuitous bailees, and it's obviously envisaged that they will continue to the next port so the owners can repossess at that point. And that's going to incur a certain amount of costs. There'll be crewing costs, there'll be bunkers. Not sure what other costs there will be in completing the voyage. It's not obvious to me that insurance or maintenance obligations would continue. But where is the obligation? I think you accept that owners have to reimburse charterers for that.
I do, madam.
Where does that obligation come from?
The obligation is the correlative of the gratuitous bailee obligation.
So if you're my gratuitous bailee, you've got my asset, and you're taking it to somewhere for me, I have to reimburse you the cost of doing that.
So I have to reimburse you the cost of essentially that you expend as my gratuitous bailee. So if you, for example, lock up my chattel in a warehouse and you're incurring costs in respect of that, I've got to reimburse you those costs. And that is clear from the decision called the Winson, which is referred to by Lord Sumption in the costs. Hopefully there's no debate about that, so I don't have to take you to that.
So what is, I mean, maybe I should go back to the award, but what is the argument in this case? Because it follows that you accepted that you had to repay to charterers the cost of taking the ship to Tregear. They never actually got to Tregear, it stopped in Gibraltar, but I mean, is it accepted that you had to repay them what it would have cost them to take it all the way to Tregear?
If they did take it to Tregear, yes.
But in this case, they took it to Gibraltar, so you have to repay them the cost of taking it to Gibraltar.
Yeah, so the reason that the issue arises in this case is that there was a significant period where
From May till August.
where we said take it to Tregear, bring it to Tregear, is probably a better way of putting it, but they said they weren't required to do so. So the vessel is sitting in Mexico.
And while it's sitting in Mexico, they have to pay crews, and they presumably consuming, even though they're at anchor, they're consuming some bunkers.
Indeed.
And that's what the argument's about, isn't it?
Indeed. Now, there is also another important part, and I'll come to this when discussing breach, because on one view, one can reach a conclusion that says owners were required to pay them the costs of that period as a bailment expense. However, the judge, and this was going to be a second point of appeal, the judge concluded that there was also a breach of the obligation to repossess within a reasonably practical time.
And you say there's no finding.
In fact, it's inconsistent with the finding that the tribunal makes. But that may be important because there is a dispute as to whether or not charterers would be entitled to the cost of looking after the vessel after the arrest. So the cost of the arrest, looking after the vessel after the arrest. So there's a dispute as to, well, is that a function of you as a gratuitous bailee, or is it some sort of step in mitigation that means that you're entitled to arrest the vessel. And so that question is a relevant one for that part of the chronology.
Well, if the point of law, which is before the court on section 69, is decided against you, it must follow that you're in breach, mustn't it?
My lord, it does not follow that I'm in breach. Even if I'm not entitled to select your gear, what that means is that I'm liable for all the time that the vessel is in Mexico. Because the reason I'm currently not liable is because I asked you to do something in breach, you failed to do so. So while the vessel's in Mexico, I'm liable. That does not mean necessarily that I failed to repossess the vessel as soon as reasonably practicable, because as the tribunal has found, there is the charterers have failed to prove that I could have repossessed it on May the 14th or shortly thereafter.
But this issue wasn't before the judge and isn't before us.
And that's the point. So what the judge has found essentially decides an issue that wasn't before him.
You can only decide the point of law certified under section 69, is that right?
Indeed, my lord, that's the point.
Where do we find that point of law?
The point of law is
Page 2.
probably the simplest place to find it is my learned friend's respondent skeleton argument.
Isn't it at 274?
Mrs. Justice Dias, was it?
Mr. Justice Cochrane.
Cochrane.
It's in the claim form, isn't it?
It is
274. That's where you have to look, isn't it?
The question of law, what is the correct construction of clause 29? Well, that obviously doesn't raise any question of fact. Couldn't do.
And therefore, my lord, this is why we say that we ask the findings made by the judge, and he makes them, just find a reference for your lordships. It's paragraphs 26 to 29. That he essentially finds that we were in breach, and that's a bundle, full bundle, tab 4, page 95. So the key parts are actually 96, paragraphs 28 and 29.
Now, where have we got to? I'm conscious of the time.
My lady, I just double check my notes, but it may be that. Maybe, subject to any further questions from you. There's my submission.
You've had an opportunity just to check through, have you?
Yes.
Anything else? Anything else? Well, thank you very much. If I would say we've asked an awful lot of questions and you've handled them with courtesy and aplomb, and I'm very grateful. Thank you. Now, Mr. Milne.
Thank you. My lady, court.
Yes.
So, I will try to minimise going over any ground we've covered already. To just encapsulate the tribunal's construction of the clause which was in favour of the owners, was to say that clause 29 entitled the owners to elect to have the vessel taken at the charterer's upfront expense to whatever location the owners considered in good faith to be the most convenient location to them. it couldn't be an arbitrary or irrational choice, but they held that the concept of it being convenient to owners meant convenient to the particular owners in their particular situation. Therefore, it entitled the owners to elect somewhere based on factors that were idiosyncratic, if I may put it that way, to the owner's circumstances, which in this case meant, as they approached it, the owner's lack of familiarity with the business of shipowning and the owner's financial difficulties. And this is mentioned in award paragraph 136. I don't ask the tribunal, the court, sorry, to turn that up now, but basically in 136 of the award they refer to the fact that Brodotrogir had a shipyard in Croatia with personnel who, although they were not crew, they were personnel who could keep an eye on a ship whilst it was being laid up at a berth, which they can't. Now those are very, very unusual circumstances. Ship owners in general do not have a shipyard at which they want to put a ship, and they do not in general have personnel who are not crew, but who can merely mind a vessel while it's being laid up, doing nothing. So it's a very, very idiosyncratic circumstances of convenience which the tribunal held was appropriate for the owners to take into account when making an election under clause 29. The construction which the judge upheld, which is the charterist construction, is that clause 29 is not about ensuring that in every situation the owners have a menu of 3 choices open to them, let alone ensuring that they have a menu of 3 choices where option number 3 is vast and in practice subsumes the other 2 options, as the judge had rightly noted it did. During discussions with my learned friend, Lord Justice Phillips set out, as part of the discussion, what, my lord, you described as an apparently straightforward interpretation of clause 29, namely that if the vessel's in port and can be repossessed there as soon as practicable, then it must be so. If the next port part of the clause refers to if the vessel is at sea, and the other convenient port or place refers to, certainly in our submission, where the going to the next port would not fall within repossessing the vessel as soon as reasonably practical. For example, if she just set off on a ballast voyage leaving Japan for New York, her next port was New York, at least according to the original schedule, but there's no earthly reason why she should continue going to New York, given that the charterers have no right to possess her and no right to use her, and it would be reasonably practicable to find somewhere much closer for the repossession. I simply wish to make clear that our submission is that that straightforward reading of clause 29 is correct, and my submission is that it is essentially the same as the judge's understanding of the clause as well, and as our case. And for completeness, we have looked at the issue as defined in the claim form, and that is repeated in my skeleton.
Yeah.
In the respondent's skeleton argument responding to the original appeal, which is I do apologise. In the respondent's notice, page 302, paragraph 12 of the respondent's notice, the owners accepted that the question of law articulated in paragraph 26 of the Charter of Skeleton Argument was a question that was before the tribunal and is answered in the award. That is what the owners have accepted on this section 69 appeal. They can of course take the tribunal to paragraph 26 of the skeleton. That is page 284.
So this is, sorry, the respondent's notice in the High Court.
Yes,
So this is the owner's document. Yes.
Sorry, yes indeed, the respondent's notice responding to our section 69.
Yes.
Yeah.
So it is the same wording as the claim form in paragraph 26 at the bottom of 284. So the question of law, which is accepted, was before the tribunal and was answered in the award, is not only what is the correct construction of clause 29, but in particular, does it mean and have the effect of either A or B? And we contend for A, and the owners, the tribunal, in fact, went for B. So those are the
What is the jurisdictional position? Are we bound to say either A or B?
I do not believe that the Court of Appeal is so bound. It is to decide the correct answer to the question. And therefore,
But the question, is the question simply what is the correct construction of clause 29? Or is it, in particular, does it mean?
well, if I may at least initially answer my lord this way, that if your lordship were of the view that the correct answer to clause 29 is C, and that neither A nor B has correctly captured it, then I would not seek to persuade the court that it should restrain itself and avoid saying C, because that would seem entirely unhelpful for the very purpose that section 69 appeals exist, which is to assist the commercial community.
The section 69 jurisdiction is very circumscribed, isn't it? There's only jurisdiction to decide the point of law for which permission has been given. There's no other jurisdiction, is there?
I have to accept that, my lord, and I had not been aware, and I'm still not sure, that there is a suggestion that there is a candidate other than A or B that is in contention.
No, but in principle there might be, and I think it would be helpful for us to know whether, if we thought the answer was C, we could say so or not. I mean, on the one hand, it clearly is the case, as you've accepted, that section 69 circumscribes what the court can do. It can only answer the question of law that is certified under section 69. On the other hand, it's not unknown for a court to be asked to construe a clause and come up with some compromise or third view which is not that put forward by either party.
And
so I think the question is the question of law simply what is the true construction of the clause, in which case we can produce whatever we think the true construction is, even if it's not identical to that put forward in the claim form as one of the two alternatives. Or is the question of law, is the answer A or B? In which case we may be stuck with saying it's either A or B.
well, my primary position is the question of law posed before the court what is the correct construction? In particular, is it A or B? That is to say, neither party is really prepared or is attempting to persuade the court about any option C.
Yeah.
So, thus far, I am not aware of a rival contender. But
My concern is perhaps slightly is whether the wording, whether we're stuck with the wording. I'm not terribly keen on the wording as soon as practical, basically.
well,
I don't think we'd be stuck. We wouldn't necessarily be stuck with the wording, would we? Because it's very clear what the dynamic is and what A says. And if it was expressed in a different way by this court, that surely wouldn't be out with the bounds of the limitations of the section.
I have to say, sorry, this issue is not something I've been worrying about. But what I do submit is that this court cannot be bound by the party's precise wording.
Yeah.
And indeed, although I'm not in a position to cite specific authorities, it does seem to me that in many cases, courts have noted that the particular wording chosen was infelicitous, and the question might be better reformulated. If the court wished to send us away and ask if there are examples of that and how it was dealt with, please do commission us to do so. But from memory, which is necessarily not specific, I do believe there are cases where the court has departed from the precise wording in order to better give effect to what it thought was the correct legal analysis.
Right, well now you've worried about that for us. We'll let you pick up where you intended to go.
So yes, so I was just rounding off the introductory point that it is not about creating a menu of 3 choices for the owners. It's not about ensuring that the owners are given, if you like, 3 choices to choose from, whatever the situation is. And indeed, once one drops that idea that it was all about intending to give the owners an election, then I submit the construction of Clause 29 falls very neatly into place and is a relatively straightforward point. And indeed, it doesn't really make sense to see Clause 29 as intending to give the owners a choice, a menu of 3 options, simply because, as has been underlined even by my learned friend rightly, the vessel is either in a port or she isn't. So there cannot be 3 options in every case. The current port is only an option if there is a current port. If she's at sea, there's no current port, so then one looks prima facie to next port, but of course that may be problematic for its own reasons. Fundamentally, what the clause says is that the owners have the right to repossess the vessel at a port or place that is a convenient port or place. We say that means objectively convenient, satisfying an objective threshold of convenience. Must be somewhere where a master and crew can be put on board in the usual way. And that doesn't mean the same thing as it needs to be the port that the owners would say was the most convenient to themselves of all possible locations. On charterist construction, we say that all the parts of the clause cohere, and one can read them with their natural ordinary meaning without needing to rewrite or mentally delete any part of the clause. In particular, one can give effect to the natural meaning of the concept, the owners are obliged to repossess the vessel as soon as reasonably practicable, and can give effect to the normal meaning of the phrase, hold the vessel as gratuitous bailies only. I grouped my submissions under essentially 3 main headings. The first is the express language and natural meaning of Clause 29. The second is to consider what the authorities have said, and on that I'll be taking the court in particular to the BIMCO notes or commentary and Davies, which is the leading textbook on bareboat charterers, both of which I say support the charterers' construction, not the owners. And thirdly, considerations of commercial reasonableness and prejudice. I will attempt to get a good way into the first topic before the lunch adjournment. So, to begin with the first topic, that is the express language of Clause 29. The clause is at page 196 in the bundle. So, the context in which Clause 29 arises, of course, is termination, that is, the charterer's right to possess the vessel has come to an end. Their only right to possess it was under the charter. That is now over, and therefore the charterers are obliged to bring their possession and use of the vessel to an end, just as the owners are entitled to repossess their own property. On that, I do wish to pick up one specific point in my learned friend's skeleton argument. If I could ask the court to go to page 34 in the bundle, please. Paragraph 65(1), the owner's skeleton. It is not that we disagree with everything in paragraph 65(1). But we do disagree with the suggestion that once the charter is terminated, the charterers cannot, without the owner's agreement, sail the vessel to a convenient place to discharge the cargo. Certainly, I'm not necessarily attempting to define for the court exactly what is being said in my learned friend's document, but just to be very clear, if a termination occurs and the vessel is at sea en route to somewhere, self-evidently, the charterers do not have to just sit there immobilised with the vessel in the middle of the sea doing nothing. They do have to bring their use and possession of the vessel to an end. They are obliged to get their cargo and crew off this ship as soon as reasonably practical.
Does that mean if they're sailing from Japan to New York, they have to stop somewhere en route to discharge the cargo as soon as they can?
How I would answer that, my lord, is this, that the governing principle is, since their right to possess and use the vessel has come to an end, they are obliged to bring their use and possession to an end as soon as possible, as soon as practical. That's the governing principle. Sorry, if I may just round off now. There is no other rule of the same status, but as a matter of practicality, it may well be that in many cases that can be done by completing the existing cargo commitment. If the vessel is well on its way to New York and there is a receiver in New York lined up to take the cargo, then it may well be that it can be discharged to the intended receivers at New York just as quickly as it could be discharged by diverting it somewhere else and trying to find somebody else to take the cargo. But that's a question of factual practicality. You're still within the legal test of an obligation to end the possession and use of the vessel as soon as practical. So it is not necessarily the case that a charterer can always say, I'm entitled to finish what I was doing. It is simply that in many cases that will be a reasonable thing to continue doing, and it will satisfy the obligation to remove the crew and cargo as soon as possible. Not least with one consideration is that, in general, the cargo interests will have entitlements under a bill of lading, which is enforceable through in rem claims against the vessel, which would have impacts on the owners even after the charter is ended.
You accept that if it's on the high seas, heading for a particular port, that the owners then do have the right to ask you to head for a more convenient port.
Well, I accept that the charterer, like I submit, the charterers have the obligation to end their use and possession of the vessel as soon as practical. That's already there even before one comes to clause 29. That is, if you like, the premise on which clause 29 comes into play. And therefore, one isn't reliant on clause 29 for the existence of this obligation on the charterers to stop using the vessel, to get their cargo and crew off it, because they no longer have any right to be there. Obviously, they cannot do that instantaneously, especially when the vessel's at sea, and nobody is suggesting they could. In commercial reality, the vessel would have to go somewhere, and arrangements have to be made to get the cargo and crew off. But that already exists even before one comes to clause 29.
But one has to give some content, do we not, in the first sentence to the place convenient to them?
Absolutely.
And what is the content for that then, on your case?
So just to be clear, it has never been our suggestion or our case that these words do not have any content, and we do submit it's thoroughly unfair to accuse the judge of interpreting the clause in a way that means the words convenient to them have no content. It's a right in favour of the owners that the vessel must be made available to them at a port or place that is objectively convenient for repossessing the vessel. So the charter
It's not just objectively convenient in the jungle, it's objectively convenient to the owners. So the owners must be able to specify this place is convenient for me. And the question is, what are the limits of the owner's ability to do that?
Well, it must be objectively convenient to the owners for the purpose of repossession. And as the tribunal themselves said, and it is not challenged, that is an objective standard. It is somewhere where the owner's authorised representative can be put on board and can go through with completing the act of repossession in the ordinary course of business, in an ordinary and business-like way. That is what I submit the meaning of objectively convenient means. It is not, I submit, intended to allow the owners to choose, of all the possible places in the world that could meet that threshold standard, to nominate one of them, but rather to guarantee that it is delivered in a port or place that is convenient to the owners, not in a port or place that the owners have chosen because it's the one that they like best out of all potential places where it could conveniently be done. So it is very important content of clause 29 because it's intended to ensure, and we will look at this when we come to the BIM codes, but the perceived problems were that in some circumstances at least, charterers might be tempted to simply abandon the vessel, pull their crew off, leave the vessel unattended to, might withdraw their crew at a place where they could do that, but which for some reason that creates real difficulties for the owners going through with repossession. And so it may be of a belt and braces nature, but it's intended to ensure that the owners will always have the protection of being able to put a master authorised representative on board in the ordinary course of business without some unusual and unreasonable hurdle towards doing so. And there may well be ports and places in the world where it could be said to be objectively inconvenient. For example, if it's a port that belongs to there are ports in more remote regions like northern Russia where the port serves a mine and vessels go there. But if you want to go there with anything other than a vessel, it's very difficult. Certainly not. It's not possible or not reasonably practicable to send a crew who would have to travel over land or by air. But there won't be commercial air services servicing very, very remote ports in particular regions that just service a particular nickel mine or whatever it may be. One can conceive of places where shipping does happen in the real world, where it would be objectively inconvenient for owners to have to do the repossession there.
So what you say is that the appellant's argument, the owner's argument, puts convenient as the primary right, which would mean that renders the concept of current or next port OTAs or redundant, because they have the right to name any convenient port, whereas in fact the proper reading of it is that place convenient only arises if current port is not convenient.
Yes, my lord. That, of course, does mean that convenient is always there as part of the meaning of the
Yes.
clause. It's always there as a protection. But
If the vessel is currently at port, then if that is convenient in the sense that objectively the owner can take possession there, then the clause is satisfied.
Indeed. I do submit that is the right reading and indeed the judge's decision. So, on these submissions of mine which are looking at the express language, it's important, I say, to note that the first sentence does use the language of a port or place convenient to them, rather than saying that they're entitled to repossess at the most convenient for themselves port or place. It does not say anything about the owners having an election.
Well, if you say you have a right to do A or B, that generally means you can choose.
Well, this comes down to my Lord's point that this clause is not necessarily perfectly drafted, and in particular, what appears to be happening is that it is attempting to pack a lot of content into a short phrase, and it could perhaps have been specified with greater clarity if they'd taken 10 or 20 lines to do it. But when one reads clause 29 as a whole, I submit that it is clear what is intended here, and what is intended here is not this idea of a menu of 3 options. And in particular, one strong indication that it is not going down the road of saying, well, we're saying you have a right to A, B, or C, and therefore you must have a choice between them, is this point about the current port. The current port
What you really wanted to be clear is a right to repossess at the current port, or failing that, the next port, or failing that, some other port. So it's a sort of like a hierarchy rather than just a menu of you can choose A, B, or C.
Precisely, my lord, yeah. And that is implicit in it when one reads the clause as a whole. Because clearly, it's only in some circumstances there is a current port. In others there isn't. Then you have to consider what to do. So it's clearly not envisaging a situation where you are going to have 3 choices open to you and you're free to choose between them. And it just also, as I'll come to in more detail later, it just makes such obvious commercial sense when there is this duty to repossess as soon as practicable, that the first option to be mentioned, or I shouldn't say option, the first possibility to be mentioned is the current port, which, as the judge observed, is likely to give you the answer in the great majority of cases, except when the vessel is at sea. And the judge did observe that it's unlikely that the charter will be terminated when the vessel's at sea, but it is possible. And hence one looks to, well, what does one do if the vessel's at sea? First stated possibility there is next port. But again, it is obvious that may not be consistent with the third sentence.
Why do you say it's unlikely to be terminated at sea? I thought we were being told the most likely cause of termination is the charterer's default in paying hire. That's presumably usually a monthly obligation, and there are risks for the owner in leaving an unpaid hire, sort of because he might be said to have waived the right if he does anything else to recognise the continuing nature of the charter. So if you've got a journey across the Atlantic which takes 45 days, might be very likely that it's terminated in the middle of the void, non-payment of hire.
So there are, my lord, a couple of points in response to that. I am not submitting to the court that the most likely cause of termination is charter's non-payment of hire. That's part of my learned friend's case, but there are no findings in support of that, nor was there any evidence in support of that. It relies on essentially asserting that the financial problems or misbehaviour of charterers is more widespread than, for example, financial problems on the part of ship owners. I submit that is an unsound assertion. Just based on
I'm not sure it does, because taking the analogy of a landlord, it's absolutely standard to forfeit a lease for non-payment of rent. There are circumstances in which you don't do it, if you might have difficulty reletting, but normally if you've got a tenant who can't pay, you don't want them sitting on your property, and presumably exactly the same is true of a bareboat charter. If you have a charter who can't pay, the sooner you take the vessel away from them and relet it to someone who can pay, it's an obvious thing for an owner to do. On the other hand, it's not always obvious that it's in the charter's interest to terminate the charter party early just because they stumble across evidence of insolvency of the owner, because they're not dependent on the owner's credit in the same way for most purposes, are they?
Certainly, my lord, I am not attempting to disagree with any of that analysis, nor do I submit, though, that it would undermine the charterer's case.
No, where we started was you said it was unlikely to be terminated at sea, and I was just clearing whether that is realistic.
Yes. My understanding of what the judge meant to say here, though, on this particular point, his judgment is a little garbled, but where I believe in the middle of this judgment, which was delivered orally, he sort of went back to the beginning of his sentence and attempted to correct himself, just so that the court can see the particular bit I am referring to. This is page 95 of the manual, paragraph 27.
27.
Paragraph 27. Although it may help the tribunal just to very quickly take a look at paragraph 26 as well.
Yes, what he actually says is improbable that a charterer would terminate while the vessel was at sea, and it's improbable it would be terminated by notice other than if the owner terminated for non-payment of hire.
Yes, indeed. And you see what it says there. So my understanding of what the judge is meaning on this point when he said it was, it's improbable that it would be terminated while a vessel was at sea, other than where the owner terminates for non-payment of hire.
Yeah.
But that in the course of his sentence, the judge went back and restarted his sentence to make it more accurate than he had the first time around. I'm sorry, this is probably very confusing, but it's just.
Well, perhaps we can reread that over the short adjournment. Is that a convenient moment?
Oh, I apologise for running over. Yes, George.
2:05, please.
Court rise, if you're able. Just to let you